Good morning, everyone. I appreciate you joining us this morning on this very cold morning. So I'll go ahead and get started. As Clay mentioned, I'm a labor and employment attorney with Offit Kurman, chair of the group, and not always relevant to the conversation, but actually relevant today is the name of our group, which is labor and employment, right? So a lot of us in the group focus on more employment law, and there is a difference between the two. And the difference is coming up in this presentation, which is around labor issues, which we're not going to focus too heavily on what you would think often about when you think about labor, which is union. I don't do much with unions. I know a little bit about it, but we've got a couple people in our group who really focus on union negotiations and that part of traditional labor, which you're seeing a lot more in the news today. But a lot of our group and a lot of what comes up with our clients, which we serve middle market businesses, owner run and operated businesses, at our firm. So a lot of small businesses, medium. So it kind of ranges from having 5 employees all the way to having a couple thousand employees, right? But our sweet spot's probably a couple hundred, or just like a lot of us are on the really low side. So, a lot of what comes up with those clients is employment issues. Union issues are coming up more, but our group is made up with people who have specialties in both areas. Some practice both, some practice primarily employment, which is actually mostly what my work looks like on a day-to-day basis, counseling clients on the day-to-day issues. However, part of the reason I think it's important to cover the National Labor Relations Act with small and medium business owners and the National Labor Relations Board is that it actually applies to you, even if you don't have a union. And it's one of the most overlooked areas of the law, in my experience, for small and medium-sized business owners. Folks are really often focused on, the EEOC and Title VII, which we will cover today as well a little bit because there's big updates, and I wanted to make sure even though it wasn't a part of the original programming, I thought it would be important to mention while we've got folks. But a lot of folks are thinking about those types of regulations, workers' comp, the things you're dealing with day to day, the wrongful termination issues that come up in those contexts, the state laws, leave laws, those types of things. And the National Labor Relations Act often really is overlooked. And it does apply to most private employers with some very limited exceptions, which we'll go through today. And it's been a busy year for labor and employment law. Probably the busiest it's been since COVID started, which kept us incredibly busy. But there's been a lot of changes. You've probably seen a lot of laws and headlines, and that's not just in Maryland, but at the federal level as well. So we've been seeing a lot of things going on, a lot going on with non-compete. So it really has been a busy year. It's been a busy year for the National Labor Relations Board. And that's what we're going to go through today, which I will, this thing's very touchy. Okay. Which I'll talk through a little bit here. All right. So just as far as what the agenda is for today, we're going to talk about the National Labor Relations Board updates and what that means for business owners, how this impacts them, what we're really what are the action items? What does that look like? So first, going to just kind of set some primer on the National Labor Relations Act and the board, and then go through a couple of the updates. Now, this is not going to be comprehensive of every update that has been going on, but and actually, let me just hold on one second. I'm just realizing. Sorry, everyone. Let me stop sharing for a moment. I just realized I think this is I've got one version up from this. So everyone bear with me for one moment. I'm just realizing when I'm looking at that agenda.
No problem.
Apologies. We were on early and set up, but we didn't click through all the slides. So so while I'm doing that, but I remember it. So what we'll go through is, we'll go through these things and then what it means, what are the action items? What do we do now? And then, as I mentioned, we are going to talk about the EEOC updates on harassment laws. So, all right, here we are. This is the one I sent you guys last night, which I know is the right one. And reshare my screen. All right.
Nice.
Current
Perfect. We
slide.
can see it too. Just want to confirm for you.
All right.
Oop,
So we're good.
we can see the notes screen.
All right. So let me see. Sometimes that happens. Why is that?
Good old technology.
I was gonna say it wouldn't be a virtual presentation if it wasn't.
There weren't hiccups.
Yeah. Why is it doing it this way? Let's try one more time. Current slide. Yeah, it's doing this. It's switching them on the screen.
There we go. Yeah, it's perfect.
Is it? Okay.
It's a blank slide, but oh, there we go.
All right. Good. All right. So that's what we're chatting about today. So I'll go ahead and get started there. So the National Labor Relations Act, for those who aren't familiar, it's a federal law granting private sector employees the right to form or join unions, engage in protected concerted activities to address or improve work conditions, or refrain from engaging in these activities. So obviously, like I mentioned, everyone's heard about unions. It's been in the news a ton lately. We've been seeing a lot more union activity, a lot more strikes. That's what we think about a lot with traditional labor. What comes up a lot for small and medium business owners that are not in the union context is the protected concerted activities to address or improve working conditions. That can be very broad, and it's just become more broad. So we'll get into that because that's really, I think, what's probably most relevant for folks who are joining this presentation. And that's an area that's really overlooked. And as I mentioned, it applies to most private sector employees. Some exceptions: agricultural laborers, independent contractors, and supervisors, though there are some exceptions to that. But supervisors are an exempt part of this. That's something that's really also important to keep in mind. And it'll make more sense once we kind of like dive in a little bit. But who is the National Labor Relations Board? So it's an independent federal agency that's enforcing that National Labor Relations Act. So if you're familiar with the EEOC, yeah, think about it. It's a little bit similar to that. They function differently. They have different powers. They have different authority, but it's a similar. They're the mechanism by which the law is enforced, and it's made up of a board of 5 people and a general counsel, and they're appointed by the president with the consent of the Senate. And so, meaning politics play a role here, and the law, what the NLRB is focusing on, their interpretation of the National Labor Relations Act is subject to who's on the board, what their political leanings are, whether they're pro-labor or pro-business. So, they serve 4-year terms, but they set, that board, the 5 people in the general counsel, they really set the tone for enforcement, what's going to be enforced, how it's going to be enforced, how, what demands they're going to make of business owners that are in violation. They set the tone for all of these things and lead us to our conversation today, because the current board is very pro-labor. And so we're seeing the board is really reverting to more broad pro-labor, pro-employee policies right now. And this year, probably monthly, we've been seeing updates come out from the National Labor Relations Board, changing course from what's been going on over the last couple of years. So they're at the top, they're setting the tone, they're putting out the papers on here's what we're going to be doing. And then we've got all the regional and sub-regional offices that are actually, boots on the ground doing enforcing. The general counsel right now is a Biden appointed pro-labor general counsel, which, though this is a politically driven conversation in some degree, we're not going to get into politics, just more stating facts around, it really does matter who's, Democrats tend to be more pro-labor, Republicans tend to be more pro-business. That's just, often how these things shake out. But the general counsel we have right now is very ambitious on prosecuting cases and pushing pushing forward her agenda. The way that we get our guidance on what's happening, how enforcement's going to take place, is the National Labor Relations Board has their own body of essentially case law that that we turn to. So that's just a little bit about the board and what that looks like. And I'm not going to go into, this is not going to be a deep dive into the weeds so that when you all leave today, you feel like you can go handle a case before the National Labor Relations Board. We're not going to do that. I'm not going to turn you all into mini attorneys, but I do think it is helpful to have just kind of an idea, and they will be circulating these slides, I believe, Clay, right after. Yeah, okay. So you'll be able to, and this is from their website. The National Labor Relations Board has pretty good resources on there, and I thought, I think this chart is helpful if you're interested in understanding, hey, if my company was charged with an unfair labor practice, what would that look like? Like, what would we go through? How would this work? And this will lay it out, but essentially there'll be an investigation, and it works as like a pseudo judicial function. So it's not court, but it ultimately might get to a court, and it works in a similar kind of structure in the sense that, it's a formal process. There's a complaint, you answer these things, there's an investigation, hearings on the issues. And the National Labor Relations Board General Counsel or their designees on the regional level, which is actually who you're dealing with, will be prosecuting the charge, and then you and your counsel would be fighting that charge. So that's just a little bit on kind of what that looks like and how it works its way through the system. All right, so just to kind of set the tone about the changes, I want to just talk about a couple relevant applications of the National Labor Relations Act. As I mentioned, we're not going to spend a ton of time on unions. It's not my practice area, but I do think it's worth noting, especially in the current environment, that small employers, while it's less likely that the employees will unionize, they can. I mean, they have the right under the National Labor Relations Act. If you're a small business and you have 5 people and everyone's a supervisor of some sort, probably no right to unionize there because supervisors are exempt, and that's, it's a little bit different. But if you've got 15, 2 of them are managers, the rest are employees, they can unionize. It's unlikely, just given the size. Normally people feel that they can, because the point around unionization is to fight collectively for changes in pay and conditions. And a lot of times on a smaller company level, employees feel the ability to do that without needing to unionize. So it doesn't happen as often. That being said, we are seeing it happen in smaller businesses, and it is possible. And I think that's a common misconception that, well, I'm too small to care about unions. It is something to at least be aware of. I know I live in Hamden in Baltimore City, and we actually just had our coffee shop common ground. The employees worked to unionize, and while they were in the process of doing that, the business shut down. My interpretation of that, which I have no factual basis for, but just is that maybe the business wasn't doing well to begin with, and the unionization happened, and they're like, okay, forget this, I'm not doing this anymore. And the employees now are running the business. They've bought it and they're doing a collective. So that's something we're also seeing a lot of. But just an example, I think they had maybe 8 or 10 employees at that coffee shop. So I think it's definitely worth mentioning, but we're not going to spend a ton of time on unionization, but I do want to mention it. Independent contractor classification. So the National Labor Relations Act covers employees. It does not cover independent contractors. Naturally, that means that sometimes there are contractors who are individuals who are classified as contractors who feel that they're actually should be classified as employees and should be able to join the union that the company has, or be protected by these laws. And they'll fight. They'll go to the National Labor Relations Board, and they'll fight and say, look, I think I'm actually an employee, I'm misclassified. So the board has its own test for independent contractor classification. And we'll go into this in a little bit more detail, but independent contractor classification is one of the biggest headaches for a lot of small businesses. There are so many tests and they're all very fact specific. So if you've ever dealt with this issue, you can now add the NLRA independent contractor classification test to your list of tests that you need to know about, in addition to IRS, state tests, and FLSA. So, there's several different tests. They want to make it nice and easy on you, and so that you never have to call a labor and employment attorney, and so that you can easily administer these things yourself. But being sarcastic, it's a mess, but we'll go into this a little bit more detail. Concerted protected activity is one that is going to be where so much of what we talk about today is going to flow from. The basic concept here with concerted protected activity is that employees have the right to act with coworkers to address work-related issues, which sounds really simple on its face. So I think that there's asbestos in the ceiling in my office, and I'm really concerned and the office won't do anything about it. Well, if I want to get together with all of my fellow employees and launch a complaint about it, or those types of things, like there's mold growing in the kitchen and no one's addressed it. Our wages are too low. The supervisor is bad and we're trying to address these issues. Those can seem kind of obvious. Whereas a lot of the ones that we deal with more often as employment counsel are the things that are on the fringes a little bit, and especially with social media. So for instance, someone posting on their Facebook, Bob, my manager, is a real piece of crap. I can't believe he's making me work these hours. I hate it. I hate him. And I can't believe this company is doing this to me. Well, I'll get an employer who will call me and say, I want him to take this down. Like, this is, defamatory. This is, because of course it's not pleasant to see those things, and can be damaging to the company. Well, if that employee then has, let's say 30 of the employees he's Facebook friends with, and they're liking that post, that's an example of concerted protected activity as well. So that's where we kind of get into these areas where it's a little bit harder for people to recognize these things, and that employers are not, in my experience, when I get that call, employers, the National Labor Relations Act is not on their mind. It is not even anywhere close to something they've thought about to address these issues. So it's an important thing. And then the other place that we see a lot of it is in handbook policies and disciplinary policies, where we've got, and the board has a lot of guidance on this about what, and it changes frequently, what you can include as far as insubordination and as far as disciplinary action, to make sure that you're not silencing employees through your policies. So those are a couple areas that these come up. And the teeth on this is that you can't terminate or discipline employees when they're engaged in this activity. So you can't, for that, my Facebook example, say, start treating that employee differently because they posted that. You can investigate it and figure out, okay, well, what's going on with Bob, and is this a good situation, those types of things. And you probably should do that, but you can't threaten to discipline them for posting that. You can't suddenly start retaliating against them, terminate them for that. You also can't overly probe them about, you can investigate it from a perspective of, you should probably do your own independent investigation, but you can't be intimidating them and pressuring them about these activities. Like, hey, I heard that you guys are going to all stop working tomorrow because of working conditions. Like, tell me more about that, and call them into your office and say, tell me what your plans are, and intimidate them in that way. So those are a couple examples of that. We'll get into more detail there. All right. So as far as, and any questions coming in at all, or anyone have any questions on just kind of that framework, put them in the chat before we move on, because I know that was a lot of information. I don't see any, I'm just checking, but.
Yep, no questions so far.
Alrighty. And I'll take questions at the end as well, but I just want to, you can also stick them in if you'd like. So as far as updates this year, I mentioned when we started that there's been a lot. We're not going to cover them all today, but especially primarily the union ones we're not going to cover today. But the contractor classification test has changed. That's one of them. So in the past, there was a contractor classification test that was really focused on one factor, which was entrepreneurial opportunity. Meaning, are they able to be somewhat in control of the direction that they're going? And just some context here. Independent contractor classifications are an issue for employers just beyond even this analysis. As I had mentioned, there's a lot of tests that are incredibly detailed. A general rule of thumb I often give to people when looking at contractor classification is, if you think about a plumbing company, your primary job as a plumbing company is you employ plumbers, they go out, they fix the plumbing for people. And then maybe you've got some other types of things you do as a function of your business. So you might have a marketing company that helps you market your services. You might have someone who helps you with your accounting. You might have, these other functions that are not primary to that. If you're looking at a plumber who's working for your plumbing company, they almost never are going to be a contractor under any of these tests. They're engaged in the primary part of your business. You're controlling them. They probably aren't working elsewhere. So they're not going to be a contractor under a lot of these tests. Whereas if you've got someone helping you with your website and your marketing initiatives, like that might be a contractor depending on how they're working with you, because they might be working with other people. They might have, they might be a consulting company that you've hired. They might, and then that starts to look more in the contracting area. Relevant to the board and what they're up to. In the past, they had applied a stricter, I guess a little, or actually a little bit, I should say, looser analysis, where they were finding more people to be contractors than to be employees, and less people to be misclassified. Now we have a new analysis where it's drilling down further into these roles around, really they're realistic. So this is a good piece here, this realistic language. Because a lot of employers will say, well, they can go work for anybody else. I'm not stopping them. Well, is there a realistic ability? Is that really a part of their job? Is that something that's really happening or likely to happen? Proprietary or ownership interest in their work. I mean, so we're really starting to drill down into a more detailed analysis here, and control over important business decisions. So are they, independently doing these things? So a lot of time, this is going to lead to a lot of people that are misclassified. This is relevant with unions, because if you are excluding someone from a union because they've been misclassified, that's going to be its own harm. Or if you're terminating a contractor based on some type of, so if a contractor posted that same post on Facebook and you're like, you know what, we're parting ways, I don't want you to be an independent contractor for me anymore. If they're properly classified as a contractor, you can do that because they're not covered by the act. It covers employees. So that same employee, or same individual, I should say, if they're classified as a contractor, you part ways with them, and then they file, the board investigates or they file a complaint with the board, then they're going to look at classification. And if they're misclassified, then you could be held liable for having terminated them for that behavior. So that's where that comes in. All right, the updates on protected concerted activity. So this one's kind of going in the other directions. So on the independent contractor test, it had been really broad, kind of loosey-goosey. Like, okay, like, let's just kind of see if they feel like contractors or not. And now we're drilling down to this very specific test. Protected concerted activity had been the opposite. It had put this, and the board has found this year that the test that they've been utilizing in the past was overly restrictive and creating a hardship for employees to be able to engage in protected activity and their behavior to actually be protected. So in this one, the previous test was incredibly rigid, and I've got it here. And it had to check all of these boxes. You had to say, all right, the statement was made by this employee, and they, and they did it in these circumstances. They did it like it had to be affecting multiple employees attending a meeting. It had to be very specific. And now it's the new test as of this year is abandoning those specific tests and is reverting to the previously established test around just a totality of the circumstances. And really just looking at the circumstances and saying, and I like using this LinkedIn example Facebook example, because I think it's one of the more common ways we see concerted activity now, with social media is a big platform for that. It really just has, instead of there being some active intent by the employee that they're trying to engage in this concerted activity, the board's no longer putting the onus on the employee and that intent. They're instead saying, well, can we make that conclusion based on what they're doing? All right, all these employees liked it. It's more about the listener as well, about the objective of inducing the group and kind of what the response is to the to what they're saying and to the action. So it's a lot looser, and that's a lot more favorable for employees, and it's a lot more likely that these policies can, that certain policies and policies can be in violation and behavior can be covered. I mentioned that, so because these laws change so frequently based on the politics of everything, in my practice, and I think generally our group does this as well, even though there's been a more rigid test recently, we have generally advised clients often to still tread lightly as it relates to employees who might be engaged in concerted protected activity, to exercise caution with their policies and disciplinary procedures, because things change so frequently. So, for us, it's with our clients, we tend to, and there's reasons that, obviously we give specific advice based on circumstances, and it depends on the behavior. This is the point in the presentation that I always like to get to, which is I'm a lawyer. I have to say it depends. It depends on the facts. There's never any, one answer for anything. But, we definitely very much advise our clients to err on the side of caution when it comes to protected concerted activity, because there's a lot of things that can be considered in that bucket and protected. And the other interesting thing the board's doing here, which is fairly unique, is that they're also protecting employees who are advocating on behalf of non-employees, such as interns or contractors. So if an employee is advocating for the working condition of a contractor that's on site, they can't, that's considered concerted activity as well. It doesn't have to be just employees. And a quick reminder here on this, this does not apply to supervisors. So this is really rank and file employees that we're talking about here. This starts getting us into kind of the practical application of these things. So we've gone through what's protected, kind of where these things come up. So behavior that's happening that the employer might try to clamp down on because of reputation issues and management issues. Policies in your handbook, unionization, and figuring out how to handle that. But some places that we really see this play out, severance agreements is one where this has been also a big change and has required us to work a lot with our clients to update their agreements. So often employers use severance agreements when an employee is leaving to just part ways, even if they, to ensure a smooth transition or to try to prevent the employee from speaking illy of the company, to put in restrictive covenants like non-solicitation and non-compete agreements that they might not have had in place previously, to add in confidentiality provisions they might not have. So I'll kind of, I'll demonstrate this through an example. Most often when I get a call from a client who wants to terminate someone, especially people who are in a protected class. So let's say we're hiring or we're terminating as a company someone who is over 40 and who is African American. And we feel, okay, well, we feel like we haven't done anything wrong, but we don't have them under a non-solicitation, and we're afraid that they're going to take employees with them. And they have had access to a bunch of confidential information, and we don't have them under a confidentiality agreement. We don't think we've done anything wrong. We just need to part ways with this person. Well, a severance agreement can be a great way to start cleaning up some of those issues, provide them a smooth landing and a smooth transition, while also getting them to waive various rights and not having to worry about any future claims that might come down the road. So severance agreements often great tool for that. What's often a big part of these severance agreements are the non-disparagement clauses and confidentiality provisions. Confidentiality provisions can cover what confidential information that employee has had, but also often we'll say you can't share this agreement with anyone except for your close immediate family and your advisors. So like your lawyer, your accountant, because a lot of companies don't want employees going around saying like, hey, next, if you get fired, you should ask for severance. I got all this money. You should do that. Right. Or they don't want people talking about the negotiations around the severance agreement or any issues that might have been there. And then the non-disparagement often will be in there saying, you can't talk badly about the company. If you do, you have to pay your severance back. So this year, the board made a couple of rulings as it relates to severance agreements specifically. And they found that confidentiality provisions in those agreements are a violation if they prohibit employees from disclosing the agreement to any third party. So a lot of times these confidentiality provisions, as I mentioned, they'll be broad enough to say you can't talk about this with anyone but your advisors. So that includes a ton of people. And the board is perceiving that their interpretation of that is that it's a violation of the act because that would include other employees and the board. And that would take away their right to complain to the board about any type of working conditions or issues. And take away their right to talk to other employees about working conditions, their wages, so what we have to do now is to narrow that definition and exempt the protected activity from these provisions. Because key to severance agreements more just generally also is that employees can't waive their rights to engage in a board investigation or an EEOC investigation or an equivalent or any type of government investigation. They can waive the right to recover damages associated with those investigations. But if you ever look at any severance agreement that a lawyer's put together, it should say something around exempting those types of behaviors. And this is similar to that, is that, one solution is to adjust that language and make sure that the employee is still able to participate in board activity, go to the National Labor Relations Board, and engage in concerted activity. So that's one. The other is the non-disparagement provisions, which again is very similar to this. The board is seeing this a general non-disparagement, which is essentially just don't talk crap about us, to anybody. And that's what most non-disparagements have said up to this point, because you want it to be broad. You want to be able to enforce it. You want to be able to claw the money back if they go around town, besmirching your reputation. So the board has said, well, that also is not permissible, because under the act, they need to be able to go and engage in that conduct and talk what would be considered poorly about their conditions and their, issues they've had with the company. So we've had to, again, really carve out those types of actions from, it's not that you can't have these in your agreements, but you just have to be, and I kind of went in reverse order here on the bullets, because the reason this is important, it's not just that it's not enforceable. It's not just that if you put these things in your agreement that you can't enforce them. It's that the board has found that it's an active violation of the act to even present an agreement that runs afoul of the law to an employee. So you could, in theory, present the agreement to the employee and then never sign it, nothing ever happened, and the board could, find that as a violation. So, that's a pretty strong stance, I will say, from them. A lot of other areas of the law are not this way. So it's a pretty strong stance. And I see a couple, I don't know if there's any.
Yep, we got one question there from Cassandra.
All right. Yep, I definitely can, Cassandra will definitely can get in touch with you about that. Awesome. Okay. All right. Severance agreements. I think that is it, but definitely want to go, take a look at your agreements and make sure that they are compliant. All right, I'm going to check on time here. All right, join me. All right, non-competes. All right, this has been, I left this one for last, because this is something, non-competes are a mess, in a nutshell. It's been trending this way for a long time, in courts, as far as upholding non-competes, not upholding non-competes. So this is real, it's all coming to a head this year between, the Department of Justice, the Federal Trade Commission, the National Labor Relations Board. They're all joining in together and taking on non-competes. A lot of it's at direction of Biden, and is not of President Biden. It's not surprising, but here's where we are as it relates to the board, is that the General Counsel has taken a strong stance that most non-competes are a violation of the act. And the reason behind that is that it prevents employee mobility. So whether we're talking about the board or the Department of Justice or the Federal Trade Commission, they all have a similar theme of why they're taking on non-competes, and it's around employee mobility. It's around the ability for employees to leave when they don't like their job, they don't like their working conditions, and go elsewhere. And as you can see as a theme, that's what the whole act is about, right? The National Labor Relations Act that's what it's about. It's about employee mobility. It's about employee ability to have some more bargaining power than they would otherwise just by themselves. So concerted activity comes down to that. Unions comes down to that, where essentially the board's main goal is we want employees to be able to, because one employee in a 500 employee company is not that the company doesn't like that employee, doesn't take value from their services, but one employee walking, one employee yelling, it's one employee out of 500. And if it's a non-supervisory employee, a lot of times that screaming doesn't really matter. They can move on pretty quickly from that employee. So all of these things are all around employees being able to group together, ask for changes, and then leave and do something else if they don't, if they don't get what they want. That's a big component of this, and that's what the general counsel is really highlighting here with non-competes, is that if you've got a strict non-compete non-supervisory employees, they can scream and say and shout and say, like, we're going to resign, that we're going to, 30 of us are going to resign from this one department if you don't pay us more, if you don't get rid of the mold in the kitchen, if you don't, whatever it might be. Well, if you've got if they all have non-competes, that really limits this is the point she's making, right? Is that really inhibits their ability to actually deliver on that. So that's really in a nutshell. I mean, I've got the more detailed account here of what her findings are, and it's also related to non-solicitation. Quick primer on difference between non-competes and non-solicitation. Non-compete is you won't go work for somebody else who competes with me. Non-solicitation, you won't take people with you. Generally speaking, non-solicitations are more enforceable than non-competes. And non-competes have become increasingly unenforceable or challenging to enforce. But she's targeting both of these because she's also saying not being able to take employees with you and get a group together and all leave together is also a violation of the act. So this one's one of the more new updates in the last couple of months. And we haven't really seen how the enforcement's going to play out yet. So unlike the Federal Trade Commission, so you may or may not have seen, the Federal Trade Commission came out saying that they also feel that non-competes are largely unlawful because and the reason the Department of Justice Antitrust Division is involved is because the theory both for the FTC and the Department of Justice is around the restrictions on trade. And they're focusing a lot on the impact to the economy when employees are not able to freely move about and work where they want to work. Those are not in effect yet. The Federal Trade Commission's taking comment. They haven't ruled on anything. And then we do expect that there's going to be legal challenges when they do adapt the rule on the Federal Trade Commission side of things. So that's going to play out really, really slowly. And then we get another president in office, it might not happen at all. So we'll see. So I mean, who knows? This, on the other hand, with the board, General Counsel Abruzzo is going to start enforcing her take on this, right? She's going to start prosecuting these matters. So we're going to have to see how that plays out. And she has a much quicker road to being able to make an impact here. So stay tuned on that one. I think we're doing perfect on time. I got myself a couple minutes to finish up on the EEOC. But so what now? Review and update your policy documents, employment agreements, and severance agreements. Looking at your disciplinary policies and making sure that nothing in your agreements are out of order here. Assessing your independent contractor classifications. If you have independent contractors, you should always be doing this. And the last note I'll have on that is a lot of companies make use of misclassified contractors. And it makes business sense to take the risk. They know they're not classified correctly. But as a company grows, that risk becomes less worthwhile. You become a bigger target for enforcement by the board or by other agencies. So something to always be monitoring, especially if you're a growing company and you've made use of contractors because you kind of have had to because you can't handle the cost of the overhead for employees. Definitely always be reassessing that. And then monitor developments and what's going on with the prosecutions, because with these changes, we'll get a body of essentially board case law that will play this out and see where things go. All right, and in closing, I just wanted to talk a little bit about the EEOC's proposed guidance on harassment. The comment period for this just ended yesterday, and I really want to highlight it because it's the first new guidance we've gotten on Title VII harassment in 25 years. There was some proposed guidance that came out in 2017 under the Trump administration that was never adopted. And now we've got this guidance, which is incredibly comprehensive. It's 144 pages with examples. Bolding's a little weird on this, so but the and I think that a lot of times when the EEOC comes out with guidance, and we saw this during COVID, it really intimidates people because it's so long and it feels like a lot to comply with. But really what the EEOC guidance is doing is taking what we've already been seeing happen in the courts and giving business owners a resource and guidance on it. And also it's giving us a roadmap of what the EEOC is going to focus on from an enforcement perspective. So it's actually incredibly helpful and not scary at all, because we'd rather know what they're going to focus on. We'd rather them tell us and give us examples and give us guidance, so that when we, have a client that says like, hey, I have a complaint against me for gender identity harassment, or, sex-based claim on these things. It's so helpful to be able to have a roadmap from the EEOC of how they're going to view these things when we go into these matters. And it also, from a preventative perspective, allows us to work through things with clients, having a little bit of insight on where things are headed. So the new guidance, among other things, again, I said it's 144 pages. The guidance lots, and it'll get longer. It'll be added to maybe a little bit, but it deals with a lot of things that we've already been dealing with our clients, which is sexual orientation and gender identity, which has been playing out in the courts and also on a state basis. So this started being swept up under Title VII more recently, but even before that, state by state, states were passing specific laws on protecting these categories. Sex-based harassment based on pregnancy, childbirth, or related medical conditions, including reproductive decisions. So that's birth control and abortions. So not retaliating against an employee who's had an abortion or who has, uses certain types of contraception. Religious expression is an interesting one. And this is actually some guidance on not someone expressing their religious beliefs, but actually them doing it in a way that creates a hostile environment for someone who doesn't share those beliefs. So that's an interesting one. Social media and remote work harassment. So that's something we've all been having to, figure out, as especially when people went largely remote. Okay, well, what do we do now if someone's being harassed? How do we, does that still count? Like what's going on with social media. So if everyone, a lot of employees are friends with each other or follow each other on social media, and then someone posts something that is bigoted on social media, well, that's their private social media. What do I do with that? Is that still harassment, even though it's outside the office? The answer is yes, depending on circumstances. But just because it's outside the office doesn't mean that it can't be work related, I think is really the moral of the story there. But there's a lot of guidance on that. So this is really just the tip of the iceberg as far as what's in there. But really what we're seeing is the EEOC is working to address modern workplace concerns that employers are dealing with. And I think employers should really see this as a good thing that they're putting out this guidance, because regardless of whether you agree or disagree with their assessment of these situations and what should or shouldn't be protected, as a business owner, it provides you a lot of helpful information, and your counsel a lot of helpful information on what's going on inside the brain of the EEOC, where things are headed, what to do with some of these issues. Because by and large, when I do trainings and things, people just want to know how to handle. They just want help figuring things out. They want guidance. They want to know what the rule is, and we'll comply with it. I mean, it was the same thing during COVID. It's like, I want my employees to be safe. I want to make sure everyone's okay. I want to comply with the law, but what is the law? Why it keeps changing? What do I do? So I think this will be a helpful thing for people.